Hi, my name is Vicky Biggs and I head up Myerson's Business Debt Recovery team. In this video, I will be discussing how to deal with defended business debt recovery claims. So on what basis can a business debt claim be defended? For any number of reasons, a business might want to dispute a debt claim. Perhaps the debt claimed is only partially due, has already been paid in full, or should never have been invoiced. Disputed or defended claims for debts usually arise as a result of disputed issues of fact, often around the quality of the goods or services provided to the debtor. As debt recovery claims can arise in a variety of circumstances, the defences available will always be different and unique to the specific case. If you instruct a specialist debt recovery solicitor to defend a debt recovery claim, they should be considering issues such as: has the relevant deadline for pursuing the debt expired? In England and Wales, the businesses have 6 years from the date the payment fell due to pursue the unpaid debt. For example, if payment of the debt fell due on the 9th of June 2022, the creditor has until the 8th of June 2028 to issue court proceedings in relation to the debt. After this 6-year time frame has elapsed, any claim becomes statute barred, meaning the debt cannot be pursued. The burden of proof is on the creditor to show that the 6-year time limit has not expired. Something else to think about is whether the creditor is guilty of any illegality, i.e., illegal activities or conduct, meaning the debt is not payable. Something else to think about is whether the relevant contract has been rescinded, i.e., has the contract been set aside, meaning the party should be put back into the position they were in before the contract was made. If court proceedings have been issued, has the claim been brought in the correct jurisdiction? It is possible to argue that the court in which the claim has been issued has no jurisdiction to determine the claim. Typical grounds to contest jurisdiction include that the dispute involves an extraterritorial element and the court where the claim has been issued has no competence to decide the claim, and/or there are public law considerations which mean it is inappropriate for a local court to try the claim. In addition to what I have just mentioned, any solicitor dealing with a defended business debt recovery claim should be considering if there are any counterclaims or set-offs which either partially or wholly extinguish the claim. So what is a counterclaim? A counterclaim is a claim brought by a defendant in response to the claimant's claim. The counterclaim would be included in the same proceedings as the claimant's claim. In a business debt recovery context, a counterclaim may be appropriate if, for example, the claimant has supplied faulty goods or supplied services which are not of a satisfactory standard, and this has caused the defendant financial loss. So what is a set-off? Where two parties have financial claims against each other, a right of set-off allows them to deduct one liability from the other, so that only the balance is due. Any cross-claim may be asserted in a dispute, however, not every cross-claim is a set-off. Set-off is normally a defence or excuse for non-payment. This makes a right of set-off more valuable than other cross-claims because set-off may excuse what would otherwise be a breach of contract so that it does not trigger termination of the contract or other rights which may arise when a contract is breached. In English litigation, a set-off claim can prevent a creditor obtaining summary judgment on an otherwise undisputed claim. For those wondering what summary judgment is, the court may give summary judgment against a claimant or defendant on the whole of a claim or on a particular issue if the party has no real prospect of succeeding on or defending the claim, and there is no other compelling reason why the case or issue should be disposed of at trial. So what evidence is needed to defend a business debt claim? The evidence needed will depend on what basis a business wants to defend a debt recovery claim. The court will consider a mixture of documentary evidence, evidence from an expert witness if appropriate, and evidence from witnesses who can provide factual information. If the debt has arisen due to a contract that was entered into, the creditor will often rely on the terms of that written contract when bringing its claim. For businesses wanting to defend a debt recovery claim on the basis that the terms of the contract have not been complied with, you will need to provide evidence of the same. This could take many forms. For example, email correspondence exchanged between the parties when an issue has arisen. It is important to keep copies of all correspondence and documents exchanged when an issue arises, because both your solicitor and the court will need to see this. Retaining copies of emails and letters sent and received is relatively easy, but also think about taking a note of any telephone conversations or meetings you have when you are trying to resolve an issue, as these can be crucial in either resolving a dispute or when asking the court to determine the claim. Taking a note of a meeting or telephone call can be very useful, because it can be difficult to recall the details of a meeting or telephone conversation many months or even years after it has taken place. In circumstances where a business is defending a debt recovery claim on the basis it has suffered financial loss because of the claimant's actions, you will need to provide evidence of the financial loss suffered. This could take many forms. For example, you may need to produce invoices of payments made to third parties who have supplied replacement goods or services to you because the claimant was unable or unwilling to rectify faulty goods or services it had supplied to you. Sometimes expert evidence may be required when defending a business debt recovery claim. For example, an independent third-party expert could comment on why the goods or services provided are not of satisfactory quality. If you need help defending a business debt recovery claim, please do not hesitate to contact me or another member of the business debt recovery team by emailing us at lawyers@myerson.co.uk or calling us on 0161 941 4000.